Okay, we're just a few seconds before the designated start time, so I just want to ask everybody to make their way to their computer and get situated in. I know the staff have been helping people get into the room, and I want to thank everybody for signing in a bit earlier as it was requested. You'll note that on our participants list, you'll see 55 altogether. That's expected to go up as we go through the meeting. And with that, let me just check with the staff, perhaps to Jamie, maybe that's a question to you in terms of who the elder is or who the knowledge keeper is that'll help us with the opening prayer this morning.
Do we have someone in mind?
I just have a to be determined on the agenda, so I'm just checking with the staff to see, unless you're offering, Chief Dom.
If we don't.
Sorry, your sound was in and out there a bit.
Okay, I was going to recommend, I have Talacton who's on here, and I was going to ask if he could provide an opening.
So,
Paul Sam.
yep. Talaxon, are you ready to do that? So thank you very much for that, Chief Tom and Councillor Paul Sam Talaxon. So let us turn to Talaxon for the opening prayer.
Okay, just give me a sec.
Yeah. And just as he's doing that, very quickly in terms of your agenda, opening comments from the Leadership Council, we will have the technical briefing from Merle Alexander. Cheryl Casimir will help open up the discussion period for about 15, like about an hour. And then we'll look to the Leadership Council to provide a closing. Chief Don Tom, wrapping up as close to the 12 o'clock as we can. Over to you, Paul.
Thank you, Harold. I'm going to begin with using my language in the language of our land, which is Sinchothan. Siem Khels, Aishka Suangastuchut, not a squitcho. Quanangasta, Sumakatla, Sushesta, and Swalakwas, and Escaliskat, let's say, yes, Quen Tango. Siem Khels. Dealam Dewilson, Sumakatla, Siem Khels. Oh, 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 CM Schels, Aiska Suangestucher, not as Quito. Quanangertas, Mokche, Etletia, CM Schels, Quanangerta, Stammersta, Grand Chief Stuart Phillip, Suya, with the Gartley, Quanangerta, Stammersta, Stuart Phillip, CM Schels. I was thanking the Creator for another day. I was asking to watch your minds and your hearts, your bodies today as you gather to work for our people. I was raising my hands to all of you for coming. And I was asking Trails to our Creator to watch our children and families while you're busy doing the work, the great work that you all do. Haishka, CM, Haishka.
Thank you very much for that. I really appreciate that. And good morning, everyone. Once again, this is Harold Tarbell. I'll serve as your MC, and great privilege to be able to join you from Squamish Nation territory here in North Vancouver by way of your agenda. And so we are gathered here for the next 2 hours to discuss the federal bill C-15, an act respecting the United Nations Declaration on the Rights of Indigenous People, and to prepare the chiefs in BC for the AFN Forum on Bill C-15, which is scheduled for next week on February 10th and 11th, of which I will see you there as I'm one of the co-chairs for that session as well. In terms of our work today, we are going to look to Leadership Council to provide some opening comments, and then we'll look to Merle Alexander to provide a technical briefing on the bill itself. And then we'll ask Leadership Council member Cheryl Casimir to set a context and open up the discussion period on the bill itself. And then we'll look to Chief Danton to close the meeting and then prior to the closing, prior as close to the noon hour as we can make it. Just want to remind everybody, I would note that a number of people, including myself, are having some kind of interesting technical issues this morning. And so we just got to be conscientious about that. I will note as we go through the meeting, when we get to those opportunities for discussion, we will be looking to use the raise hands function. And so often that's at the bottom of your participants list, and when it's not open, you would click on the participants button at the bottom of your screen and it would open. A number of people have indicated that it's also, for them, it's in the reactions button, and it is the raise hands function. What that does is it puts a hand by your name and moves your hand up, your name up on the speakers list to draw our attention to it. And so we will look to do that. But given the number of participants that we do have online and the amount of time we have here, of course, we won't be able to get to everybody. So you are reminded that the chat function is also open. So if you can enter messages and comments to everyone there or to individual members participating. And so that's available as well. We are recording the meeting. And so both the video, the audio, and the chat messages either to the host or to everyone will be recorded. Chat messages between participants are not necessarily recorded, although it is important to be conscientious about that. I always suggest treat it more like a postcard, just because it is a technology platform itself. I'm just going to check here in terms of a participant. Yeah, so I'm having technical issues in the sense that I'm not actually able to enter into chat, nor am I able to search my participants list. So looking for participants. And so I do see that BC AFN Regional Chief and First Nations Leadership Council member Terry Chiji is present in the participants list. And so I will turn to him for the opening comments. Regional Chief?
Yeah, thank you. Sorry about the technical issues with Zoom this morning. Daneza and Sekuza Skyza. First of all, I just want to acknowledge the territory that I'm on, Claytley, Tene, unceded, unsurrendered territory, and want to thank Paul for that prayer, and certainly as part of the Leadership Council, our thoughts and prayers are with Grand Chief Stuart Phillip today as he goes into surgery. I want to thank you all for attending today and a very important discussions with my colleagues from the First Nations Leadership Council. As you all are well aware, we're discussing Bill C-15, the federal bill to recognize the United Nations Declaration for the Rights of Indigenous People as an act. It was tabled in Parliament on December 3rd, 2020, last month. And the bill has passed the first reading and may be moving to second reading in the weeks ahead. Today is a meeting or opportunity for our region to discuss C-15 and to prepare the chiefs in BC for the upcoming AFN, Assembly First Nations National Forum on C-15, which is scheduled next week on February 10th and 11th, 2021. The United Nations, just a little general comment, the United Nations Declaration is a human rights instrument that affirms inherent rights of Indigenous peoples in the world as a minimum standards for their survival, dignity, and well-being. Really, it's recognizing our human rights. It recognizes, among other things, Indigenous peoples' unique rights to express their right to self-determination, such as the right to self-government, the right to participate in decision-making on matters which would affect their rights through representatives chosen by themselves in accordance with their own procedures, and the right to maintain and develop their own decision-making institutions. Corresponding obligations on states include the requirement to consult and cooperate in good faith to obtain the free, prior, and informed consent of Indigenous peoples through their own representative institutions. UNDRIP provides an affirmation of inherent Indigenous self-determination, and C-15 confirms that for the laws, policies, practices of Canada, Article 3 affirms the right to self-determination of Indigenous peoples. Articles 10, 11, 19, 28, 29, and 32 highlight foundational principle of free, prior, and informed consent, as known as FPIC. The standards of affirmations need to translate into legislative action to overcome impediments and create new tools and supports for Indigenous self-determination and self-government, which necessarily involves a recognition of Indigenous jurisdiction and sovereignty. Bill C-15 really presents a positive opportunity. However, while we are hopeful, we are not naive. We will face vigorous resistance and likely opposition from questions from other regions, and including ourselves. We need to really question on some of the C-15 itself, and we certainly know that other premiers in this country are dead set against this legislation. We know of 6 premiers. We're very fortunate here in British Columbia to have Bill C-41 and certainly have the experience in really trying to place a law to recognize a declaration in this province, and know of the experiences of the barriers, and perhaps our experience can lend itself to a national discussion on how best to do it. We have a short window of opportunity here on this bill, and we'd like to bring more information to the chiefs, and more importantly, I'd like to turn back to Harold to introduce the next item up in our agenda, and want to leave a lot of time for discussion with the leadership in British Columbia here. So I'll leave it at that, Harold, and thank you for chairing today, Masaicho.
Thank you very much for that, Regional Chief. And I would also note, in addition to the slight technical issues that I'm having, I also have window washers in front of me on the 17th floor. So, just not enough going on in the screen. So thank you very much for that welcoming. Thank you for acknowledging both the prayers reference to Grand Chief Stewart. And I wanted to thank Kupi Wilson for sharing with me a photo of some candles she had lit as a part of her prayer and attention to that matter. So really appreciate that. I will turn quickly then to the technical briefing on Bill C-15, and I'm just going to look for Merle Alexander to really just to give us that quick 20-minute guided tour of the legislation itself and some of the issues that have been identified. Merle, are you there?
I am indeed.
Thank you very much. Welcome.
Thank you. Just a second, I'm just gonna make sure I can navigate this for presentation here also. Just a minute here.
Will you be sharing your screen?
Yeah,
Okay.
just a second. The hard part.
Yeah, just. Yeah, so click your share button and then you'll pick your PowerPoint presentation or whichever form it's in, and then click share again. Yeah, just at the bottom of your Zoom screen, if you put your cursor there, you should see the green share window. There you go. Looks like it's opening up and it is on our screen. There you go.
Excellent. Thank you very much, and good morning, everyone. My name is Merle Alexander, and my hereditary name is Lakachnitz. Thank you very much for the opening prayer. It is such a good way. Sometimes a good way of opening meeting isn't quite enough because you really need sort of that sort of soul check-in, I think, especially in these times of COVID. And with that, of course, I think I and many other people send our prayers to those that are sort of making their way through COVID and many other illnesses at this time. With that said, given the time period and the urgency for you to sort of engage on the subject matter at hand, I'll get right into my presentation. Feels a bit like Groundhog Day, you know, because of course I've given this presentation before, and some of you have even seen it before. So I'm going to move at a fairly quick pace, and it will be as the bill goes. It will be technical in nature, and then of course we'll be available for questions. But I think hopefully we'll be able to make it user friendly and it'll be easily digested by leadership. So with that said, what the presentation is tended to do is many, of course, have sat through presentations and are well aware of the content of our own BC legislation, the Declaration of the Rights of Indigenous Peoples Act, aka DRIPA. And then I think lots of people are sort of wondering, like, how is C-15 different from that? So like going through a whirlwind, I can sort of do a comparative analysis side by side of the two pieces of legislation, hopefully answer many of those questions for you. So with that said, I'll jump right in. So unlike the BC legislation, the federal C-15 that was tabled in December 3rd last year has a very substantial preambular clauses that precede the legislation. Those preamble clauses can be used very helpfully in interpretation, and sometimes really substantive components of the legislation that maybe were not necessarily palatable, or there wasn't time to have them be made into coarse elements of the statute itself, actually find themselves within the preamble. I say that because as I go through the few elements of the preamble, you'll find that there's some really substantial commitments even in the preamble itself. So there's 20 preambular clauses. I'm not going to take you through all 20, just to touch on some of the highlights. There was actually quite a bit of discussion about whether or not there would be a preamble with the BC legislation, but in the end, the sort of legislative conventions are different federally and provincially, so the preamble didn't end up surviving the co-drafting process. But anyways, back to C-15. So there, as I said, there's 20 preambular clauses. Key component of is said in preamble 1 that the declaration, UN declaration, will be the framework for reconciliation, for healing and peace, and justice, democracy, respect for human rights, and non-discrimination in good faith. That's in preamble 1. Preamble 4 and 5 refer to the TRC's work. and the Murdering Missing Indigenous Women's and Girls report, that both of those reports very strongly sort of embrace the role that the UN Declaration may have in sort of eliminating discrimination and also just reconciliation as a framework. Preambular 8 particularly highlights, and you'll see actually this is one of those areas where the preamble is substantial, and it also has a sort of sister clause within the actual agreement itself, where really there's a really strong focus in C-15 on the human rights elements and like actions against racial discrimination. Part of that, I think, has to do with the year that we had last year, and that obviously it was front and center, the example after example in Canada of brutal racial discrimination. And I think it's fair to say that that influenced some of the preemptive clauses and also some of the substantial commitments you'll see in the action plan, but I'll get to that when I get there. Preamble 9, there's been a lot of conversation, I think, just sort of since C-15 was tabled about whether or not specific doctrines were rejected by like terra nullius, you know, other like sort of antiquated colonial like frame doctrines. And Preamble 9 rejects actually all doctrines that are racist in nature, that are scientifically false, legally invalid, and morally condemnable. It doesn't list every single doctrine because, hey, I mean, truth is, there's a lot of racist doctrines that we've been interacting with as Indigenous peoples, but it is important to note that Preamble 9 does expressly reject all such doctrines. It doesn't list every single one of them, and there has been some sort of like dialogue amongst Indigenous leadership about whether or not specific doctrines should be referenced or not. And that may be also a clause that could potentially be amended through the legislative process. So just sort of a short pause there, because I know that there has been a lot of conversation about are the right doctrines listed or not. Preamble 9 is sort of is connected to that, where the government of Canada expressly rejects all form of colonialism. Preamble 12 is an express recognition of the inherent right of self-determination. That's also captured in other policy documents. So in some respects, that's not new, but it is obviously in a statutory framework. It does have a certain sort of legal force to it. Preamble 13 speaks to the variety of sort of measures that can be taken in implementing this legislation. Interesting element here is that actually it's not just legislation that's referenced here, it's also policy and administrative measures, which there was quite a bit of conversation in the drafting of DRIPA about whether or not administrative measures would be covered. And certainly I think lots of people interacting with governments often find that there are sort of administrative measures that have the weight of de facto law. So that's actually like an important component of that preambular clause. Preamble 15 speaks to the implementation of the declaration, and this is actually this also doesn't exist in DRIPA, is this really clear connection between the declaration and supporting sustainable development and responding to concerns relating to climate change. So that connection between we all of course interface like and interact with those sort of sustainable development and climate change related issues. Certainly the Trans Mountain and many other sort of major projects bring that, the importance of that to bear in our territories on a regular basis. But here is like one of the first sort of statutory references that really makes that connection between the two. Last, Preamble 18 speaks to how this declaration can be used as a source for the interpretation of Canadian law. And when they say Canadian law, that means also case law, statutes, policies. So it's intended to be like an actual source that the courts can make reference to. That would already, probably without saying that, it would already be the case, but it is important, I think, as an easy stepping stone to sort of connect the dots. And then I think litigators in particular will probably be interested in that, because then they can invoke this legislation to ensure that the government is in fact complying with this legislation if it becomes legislation. I'm gonna make, actually, I was wrong. There actually are 21 preambular clauses. I'm gonna get right into the actual substance of the act. The only real difference on the titles is that the BC one legislation is Declaration of the Rights of Indigenous Peoples Act, DRIPA, and Bill 41 is UN Declaration of the Rights of Indigenous Peoples Act, so UNDRIPA and DRIPA. In terms of interpretation, it's worth noting that like in C-15, there's a definition section, whereas DRIPA has an interpretation section with some interpretive principles. Probably the most like noteworthy element of these two sections is that absent in the federal legislation is a reference to Indigenous governing body. That is particularly useful later when you sort of in sections 6 and 7, which I will get to, but the Indigenous governing body is the right holders entity that is to invoke the actual legislation itself. So I'll get to that, but just make a little mental note for yourself about how the IGB is missing in the federal statute. Moving onwards, both of the DRIPA and in the proposed bill have elements of referencing acknowledging the diversity of Indigenous peoples. This is sort of intended to highlight the distinctions approach. It may be particularly interesting, and I can't really go into like an extensive detail here, but it may, this particular section of the DRIPA Act may have particular interesting applications with respect to the lack of Métis rights that exist within British Columbia. I won't go into any sort of like take that issue up too substantively, but that actually this distinctions-based approach is actually going to be partially invoked, I think, by this particular element of the BC DRIPA Act. And then that's captured in preambular clauses 6 and 22 of C-15, which of course is a substantive issue for amongst Indigenous peoples, particularly the frictions and tensions that do exist between First Nations and Métis rights in some circumstances. Moving onwards. Now, in terms of the non-derogation language, substantially both the provincial bill, the provincial statute, and the federal bill, their non-derogation language is essentially similar. I think it's in the federal statute, it's actually framed in a bit more of has more of a positive obligation element to it, but I think from a pure legal analysis, the two non-derogation clauses are substantially the same. Both the federal and provincial frameworks also state clearly that the declaration will apply to the laws of BC, and then of course if it becomes law in Canada without delay. Moving onwards. In section 3 of the federal bill, there's a process for designating the minister that will be responsible for certain elements of C-15, of implementing it. In BC, like essentially MIR currently has sort of that lead, and that may be an evolving issue, particularly as there is a secretariat that is being designed that may deal with the cross-cutting nature of DRIPA in British Columbia. So right now there are some differences in the federal bill in that it allows for a process of designating a minister. That probably implicitly exists in the BC context also. Either way, it's clear, I think, probably to all of us that DRIPA and C-15 has cross department and cross ministerial application, and it's going to take a significant amount of coordination. In fact, that lack of coordination might be some of the initial frictions that we're dealing with here in British Columbia in terms of implementing the act, is getting the Crown knowing what one of its tentacles is doing versus the other. In terms of the requirement to align laws, that lies with the Attorney General of British Columbia and the Attorney General of British Columbia as the chief law officers, respectively. the purposes, like for the most part, are also very similar. As I was sort of saying, there is like a real strong human rights influence. I think that sort of like that particularly sort of was heightened last year during the drafting of the statute. So it's very express language about the universal, how this is a universal international human rights element and how it applies in Canada, and how that may be a framework for implementation. You'll sort of see as I go forward, particularly in the action plan, that has an especially core element. One of the other components of in the BC legislation is that there is a particular section that refers to supporting the affirmation and development of relationships with the Indigenous governing bodies. That's particularly important in the BC context because, as most of you know, Section 6 and Section 7 allow for the creation of consent-based negotiations and consent-based agreements with the province. I'll touch on that a little bit more, but there's a linkage there between the purposes of our BC legislation versus it not existing in the federal legislation. In terms of consistency, both laws require both federal and provincial crowns are required to take all necessary measures in consultation and cooperation with Indigenous peoples. That's the language of UNDRIP, consultation and cooperation, to ensure that that laws are consistent with the declaration. There's a distinct positive obligation. That's like that. It's important to note that that's a distinct positive obligation of both Canada and BC, and that means that it's not just statutes. It's the common law, constitutional sources, doctrines, conventions. All those things are meant to be made consistent. So that's I think that's a particular interesting element. Now on to the action plan. Both DRIPA and C-15 include a requirement to develop an action plan. As I said before, because of the designated minister element, C-15 allows for specific ministers or a number of ministers to take on responsibility of certain elements of the action plan. That probably will also be the case in British Columbia. It sort of just goes sort of unsaid. Because it was unclear, I think, which minister or if there would be a lead minister in the BC context, it just speaks to the language of being an obligation of government. And that would probably be spelled out more in the action plan itself. And to some extent, you could say that the current BC ministerial mandate letters do speak to how that cross-ministerial application of DRIPA applies, but don't want to get too far into the weeds.
And Merle, just a time check, maybe another 5 minutes or so.
Oh, that's lots of time, Harold. No problem. We're right into the real fun part, anyways. Here, so in terms of the action plan, this is what I was saying before. How there is a real distinct human rights element influence that exists in the federal statute that isn't as highlighted yet in the implementation of DRIPA. There's a very express references in the action plan for addressing injustices, combating prejudice, violence, discrimination, and systemic discrimination. There's a requirement to have human rights education. And then there's more detail about measures relating to monitoring, oversight, recourse, and remedy. The action plan is spelled out a bit more fulsomely in the federal statute and left more to the design of it in the BC context. The downside of that is that as you get further along, there's like a 3-year window to implement the action plan in the federal context. So yeah, sure, there might be more detail, but they'd also have like a whole bunch of built-in delay elements that might sort of allow the federal statute to be potentially delayed, because there's layers of that. One, there's a 3-year delay, and then the statute also isn't immediately of legal effect. There's a royal consent sort of element that allows there to be pretty substantial delay on the action plan at the federal context. moving onwards, both statute and proposed bill have annual report requirements to Parliament/legislature. Similar to the annual reports are substantially similar. And then really, as I was already sort of touched on quite a bit before, what's absent in the federal statute is there's no Section 6 and no Section 7, which means that the statute doesn't expressly speak to the capacity of the Crown to enter into consent-based agreements with Indigenous governing bodies or with right holders. So that will be a battle for another day, probably in the implementation of C-15, whereas we have express elements of it set out in both in the BC context in Section 6 and Section 7. As we all know, that's not exactly hasn't proven, the existence of those hasn't proven to the floodgates of Section 7 agreements being negotiated yet. That still too is a process, but at least there is the enabling element of it exists in the BC context. So that will allow us to move quicker to consent-based framework agreements in British Columbia than will it be with the federal Crown, I would assume. I've already sort of noted that there's sort of a built-in delay element, and that with DRIPA, the moment that third reading was about 2 days after third reading, the statute received both royal assent and came into effect. So it became law in November in 2 years ago. Whereas there's it's a two-staged process in the federal. There's royal assent, and then there will be a commencement. So we could see those be used as leverages for further delays at the federal level. And one of the last things I wanted to highlight is that in Section 9 of BC DRIPA, there's express language that allows for the power to make regulations under DRIPA. Whereas in the federal context, there does not exist such express language. So that's going to be whether or not there will be an entire regulatory process under C-15. That's going to require a substantial amount of, I think, advocacy on our part. It doesn't mean, of course, this is just draft bill. So there's still possibilities for key elements that BC First Nations and other First Nations and other Indigenous peoples in Canada may take up. I could see this issue of regulatory power being something that Indigenous groups do advocate for in a more stronger way. Also, the delay elements. So that's the whirlwind tour of the comparative analysis, and I thank you for your time.
Thank you very much, Merle. I really appreciate that. Just by way of our process, we are going to turn to Cheryl Kazimer, again, speaking on behalf of the Leadership Council. Following that, I'll provide a really brief context for the AFN meeting next week, and then we will open the floor for discussion. Cheryl?
Good morning. Thank you, Howard. Happy New Year to those that I haven't had an opportunity to see yet. I'd like to start off by acknowledging my good friend Paul for the prayer and helping us get started in a good way, and sending positive healing prayers to Grand Chief Stuart Phillip and his daughter, who are undergoing surgery today. I'd also like to acknowledge the communities that are affected by the pandemic and who are experiencing losses, and sending you my prayers and my love. Thank you, Merle, for that overview. I think that really sets the context for what it is that we're here for today, chiefs, leaders. It's for us to be able to have a robust discussion on Bill C-15 and to strategize and prepare ourselves for moving forward and determining the next steps. As you're all aware, Bill 262 was the predecessor to C-15, and that 262 passed third reading in the House, and it died on the floor of the Senate. We believe that C-15 picks up where 262 stalled, and we also acknowledge that there are some certain positive additions to C-15. All three of our organizations of the Leadership Council have reviewed C-15. And generally, we're of the view that C-15 is an improvement over 262. However, there are additional improvements that could make its implementation even more effective. As was discussed, the action plan is delayed to 3 years, and so that's an issue that we will need to discuss. There are also no substantive provisions in recognition of Indigenous consent-based decision-making, as was highlighted in Merle's presentation. And C-15, we believe, has the potential to affect transformation in the laws and policies and practices of the federal government, thereby significantly improving the lives of Indigenous peoples. And if it's implemented correctly, it could also be revolutionary. We know that this would not be an immediate effect upon royal assent. And I guess it's also important to note that we don't have a Governor General in place as of yet, but that's beside the point. But we would have to really press hard and engage on concrete measures required by the bill to achieve those transformations, namely the creation of a robust implementation plan. I think that that's going to be critical, and a decolonized process for the alignment, review, and reform of federal laws, policies, and practices. We know that the existing legislative process is archaic and it's built on colonial practices and thinking. And so you can't really use that kind of a process in order to make real change that is being required by the implementation of the declaration. So the release of C-15 resulted in a significant amount of commentary, including from Indigenous peoples, experts and lawyers and politicians and industry representative and organizations. And the views and perspectives cover the full spectrum from support to caution to outright rejection. Unsurprisingly, there is a fair amount of misunderstanding and misinformation about what Bill C-15 actually says. And there is significant opposition to the bill coming from Eastern Canada and from the provinces that Regional Chief mentioned earlier in his opening comments. So it appears that once again, BC must lead the way. We're going to be the ones that are going to have to be the champions. But that's not new to us. We're used to doing that. So BC First Nations and the province support C-15, and the Leadership Council continues to forward the position that C-15 must meet the floor of C-262, and it must not detract from the work that is currently underway here in British Columbia with DRIPA. And our resolutions remain clear that we support the implementation of the United Nations Declaration on the Rights of Indigenous Peoples. And we also support that First Nations need to be fully engaged in the development of C-15. We need to ensure that chiefs and leaders are informed and have the chance to air all concerns regarding Bill C-15. And hence we would like to open the floor for the chiefs to comment on C-15. And as I said earlier, we need to have a robust discussion that leads us to next steps, and also to prepare for the upcoming Assembly of First Nations meeting on the 10th and 11th, as well as also preparing positions and submissions to the standing committee, if that's the case or desire, as well as any lobbying efforts that we may need to take. So in closing, I'd like to thank all the chiefs and the advisors involved in getting us to this point where we're at now. I know that there are trying times, but we must not give up on creating new tools that are going to be necessary for the protection, enhancement, and support of First Nations treaty and inherent rights. And so now I'd like to turn it back to Harold, who's going to facilitate the questions from leadership. Thank you.
Thank you very much, Cheryl Kasmer. I really appreciate that. And so just a couple of context setting remarks for the AFN Forum next week. But I do let the participants know that we are using the raise hands feature. So you'll either find that at the bottom of your participants list or in your reactions tab, which you'll find along the bottom of your Zoom screen. So I'll encourage you to use that. We do have about an hour and 10 minutes open for that. Just by way of the AFN Forum, it is a forum, not a Chiefs Assembly, and so therefore there will be no motions or resolutions put forward. As chairs, I'll be working with Cedric and Weena, who you've seen before. And essentially, we've been asked to try to manage those presentations and conversations so that we're ensuring there's a diversity of views being shared. And so we're also, going to look at, for lack of a better word, those supporting the legislation, those who want to see constructive improvements in it, and then those who may be opposed to it. But we're also asked to sort of try to make sure we're focusing on some diversity from the regions and also gender diversity. So, we'll structure that as well as we can as we go through. If you go to afn.ca/bill-C-15, you will then go to the event website and you will find the registration there, the draft agenda, and about 5 background documents, which try to get to the issues that people have been raising over the legislation so far, and provide a context for that conversation. Day one, there's not a lot of time for Q&A, but we have a busy agenda and it's really information setting day. And so we will speak directly to the UN Declaration on the Rights of Indigenous Peoples. And I just want to make a correction. It was noted that I did say Indigenous people earlier. It is Indigenous Peoples, which has a governmental and international context. And so not to forget that. Minister Lametti, so we'll speak to the UN Declaration overall. Minister Lametti will speak. There will be a brief Q&A with him, so not a lot of time. Then we'll get to C-15 directly in terms of a range of perspectives. We'll hear Mary Ellen, and then we'll hear from Chief Ross Montour from Kahnawake. Then we'll turn to the BC legislation, DRIPA. Premier Horgan will in fact have a video. Minister Rusted will be available for any Q&A, and then we'll hear from the 3 members of the Leadership Council on that. And that pretty much concludes day 1. And then day 2 is wide open for conversation. Both days essentially run from 1 p.m. Eastern to about 5 or 5:30 p.m. Eastern each day. And then the second day, as you'll note on that agenda, it's plenary discussion. And so we'll be doing that search for diversity as well. Just one quick observation. I know there was some frustration during Assembly as for a matter of time management. We did need to move forward on that agenda and to the next item. As chairs, we're of course prepared for dealing with that frustration, but we're not planning to dwell on that as we go forward and pick up this conversation, given the fact that the bill is in the parliamentary process. I think that's it for the background on that. I do see that Chief Leah George has her hand up, so I'll thank you for using that function, Chief Leah, and I'll ask you to lower your hand as well and turn to you.
Thank you, Mr. Chair. Thank you, Talaxton, for the beautiful prayer this morning, and thank you for the presentations and comments, Regional Chief Cheryl and Merle Alexander. Just wondering about Section 5, where the discussion is around the audit of the current areas of federal law. Wondering if there's a way, or if that's in the amendment process, we would need to ensure that, well, that kind of work would take years to audit all of it. We need to ensure that Indigenous people have the ability to participate, and that would include resources, I would think. So just wondering what we could do to ensure that's there. Thank you.
That'd be a question to Merle, perhaps, Chief Leah, or was that to one of the leadership?
Merle, thanks.
Thank you.
Thank you very much for that question, Chief Leah George Wilson. Thank you, sister. I think you're right that that's going to be very substantial, commitment, and does need to be resourced. That'll probably, I think, at the end of the day, be more of an action plan issue. So, maybe there is a possibility for us to take a look at language at sort of elaborating some details in section or in part 6, because part 6 sort of says that the content of the action plan must include, and then I guess like right now there's a note that there should be resources, but I think the issue that you're raising might be noteworthy of trying to add some specific language there, because obviously the ability to advocate often is limited by a lack of resources issues. So if that's something that people wanted us to take on as an action item for language to consider, that's certainly something that we can take back.
All right, participants and chiefs, the floor is open. I will look for raised hands. I think waving hands would work if we need to. And as you're looking to find that, the other thing to note about the AFN meeting is that generally in those meetings, the norm is those who are opposed or critical are more motivated to speak. And so as a part of the chairs, we will be, constantly seeking that diversity of views. And so often, but that requires some preparation to be ready for that. I see in the chat that people have requested a link to the registration page. So that's been put in the chat. And again, I hope I didn't misspeak by saying Minister Rusted would be there, in the gallery during the assembly when the Premier's video is being shown. Councillor Watts, Chief Councillor Ken Watts from SASAT.
Good morning, everybody. Thank you for the presentation. Thank you to Laxton for starting us off in a good way, and thank you to Leadership Council for holding this session today. And my thoughts and prayers with Stuart today. I got a little emotional thinking about him today and how he came to visit me when I was going through some health issues before. And just really quickly though, I was wondering if Merle could elaborate on the preamble part. Is often we don't consider the preamble as having much weight, but I was wondering if you could elaborate a little more on that section and why it's so significant. And then I just wanted to make sure I heard Harold properly, that I heard you say Minister Rustad. I was getting little flashbacks there and getting a little concerned. I think you meant Rankin, but
Thank you.
I was getting a little worried there when you said Rustad. I thought, geez, are we stepping back into those times? I hope not. But yeah, just wondering if Merle could elaborate a little bit about the preamble and shed a little more light so I can understand the significance of it and why it's unique. So thank you. Chu, klako, and everybody have a great day. Chu.
Merle, and I stand corrected.
People and Rustad here this morning. I'm not sure. It's not just technology.
Yeah, more coffee.
Yeah. Thank you very much for the question, Chief Watts. Yeah, I mean, it's the major, as a general rule, like the preamble of a statute can actually have a lot of interpretive weight. So there's the core elements of the statute which are operative, but it is like an accepted element of legal interpretation that the preamble can be invoked. It's particularly helpful here where you actually sort of see, especially in the preamble, a lot of very distinct references to the human rights and anti-discrimination and anti-racism elements that find themselves out throughout the preamble. And then there are sort of sister clauses within the action plan that sort of like mirror those, so they operationalize them. But I mean, I think that the Declaration Act, or the C-15 is going to be like any statute, is going, the federal government is going to be required to be pushed to implement their own law. Like this is not going to be any different like for us than it usually is. Like governments do not follow their own statutes well. So we are going, the good thing is that we'll have a very substantial preamble that we'll be able to reference as key elements that will have legal weight. And I think when you take a look at the elements, like all the anti-discrimination elements, the references, particularly to sustainable development, climate change, you can see that there is a fairly rich preamble to draw from for Indigenous peoples or for First Nations to use in their advocacy with the Crown. So, I mean, this statute will be like any statute in the sense that it'll be something that'll be for us to probably enforce against the Crown. But there will be lots of substantial elements in the preamble, which is somewhat rare.
All right, again, I'll look for raised hands in the participants list, and perhaps as we're looking for that, I'll see if there's any indication in terms of the government's time frame for the legislation moving through the parliamentary process. So I don't know if anybody in the Leadership Council or Merle would have any insight on that. I see Regional Chief TG's got his hand up, and then I'll go to Lydia Whitson.
Well, what we understood, if you recall, back in the December at the AFN AGM was that there was a big concern about a pending election. Now they kind of put that to the back burner, but it's still in discussion if the federal government are going to have an election this spring. I think they're falling out of favors with some of the vaccine issues, seeing a decline in their popularity, but that was one of the impetus and main reasons why they introduced the bill in December of 2020. So I'm not sure. It really depends. If it isn't this spring, perhaps a fall election would happen by the federal government is an indication that I heard. Thank you, Harold.
Thank you, Regional Chief. Over to Lydia Whitson.
Mr. Chair, can you hear me?
Yes, we can. We cannot see you.
Yeah, I apologize. My link was giving me all kinds of trouble, and I ended up getting in a little late thanks to Colin. I came in on his, and then once I finally got in, my camera's not going on. So I apologize for that. I just want to recognize everybody in our virtual circle. Happy to be in one piece here in Quamachin and Cowichan, in the Quamachin village here in Cowichan, and yeah, thankful for all the introductory pieces to this. I just want to ask, sort of from a trying to get an understanding, of where some of that pushback against the declaration and the support for the declaration comes from. And from what I understand, when I've heard raised is there's a real pointed concern with respect to section 46 of the actual declaration. And without reading the whole section, the concern seemed to be that there wouldn't be any action that would dismember or impair totally or in part the territorial integrity or political unity of a sovereign or independent state. And when I read that, I just have heard some pushback with respect to support coming from other parts of the country that this article puts a limitation somehow on and is being interpreted in certain ways. So I'd appreciate an interpretation or a little bit of an understanding of that section, because I think as we go through this process, as British Columbia sees this as we here in BC, as First Nations here, see the opportunity going forward in terms of a real legislative framework that Canada needs in order to move forward. I just want to be able to get a better understanding of what that pushback and how much weight there is to that interpretation that somehow that would limit the ability or somehow limit agreements, Indigenous, any treaties or other agreements going forward based on this limitation. What is the interpretation there? I'll asking legal counsel, please.
Over to you, Merle.
Decent, if you have to help me on this also. I thank you very much, Lydia, for that very cerebral question. Yeah, I mean, there's definitely some pushback, particularly from historical treaty First Nations about the potential interpretive concerns around that and other elements of C-15. And of course, you've even seen those who sort of like watch are sort of news watchers, you've seen some Ontario First Nations come out in actual opposition to C-15. There's, I don't think that, I think that like from amongst the BC, like amongst the First Nations Leadership Council, Legal Council, we do not see that concern about territorial integrity being a live concern. We think that section 35 and the elements of UNDRIP itself will not sort of allow a statute to infringe Aboriginal Section 35 rights or our own Indigenous legal orders here in British Columbia. So we do not have that same concern, but certainly there is some elements, I think, within particularly historical treaty groups back east that this is sort of that allows for backdoor elements of this statute to infringe upon treaty rights. But that just isn't the hierarchy of the Constitution with statutes that are created thereunder. I mean, that's in some respects like why Section 35 has that sort of like that constitutional status. Only like in very specific circumstances can any statute potentially infringe an Aboriginal or treaty right. And there is, of course, as we know, an entire body of law around justifiable infringement. And at this point, we don't really see that concern. It is important, though, that to note that the analysis of the statute is still sort of at somewhat of a preliminary nature. Like we haven't at the FNLC, or at least not the IBC AFN, I shouldn't speak for the other organizations, haven't gone through the sort of fine-tooth comb and done an interpretation of like every single element. We're sort of waiting to sort of see where the legislative process sort of how it unfolds. Because as I was sort of saying, the bill is somewhat in play and has only had its first reading. I think the more like sort of in-depth analysis will probably sort of follow as the statute makes its way through legislation. Plus, we also do need to hear a bit more from the concerns of historical treaty First Nations in particular, what their interpretation is, because right now the analysis is somewhat superficial on that. So, I mean, those are sort of my initial thoughts on it, but certainly other lawyers, particularly Summit's legal counsel, which I see on the participant list, might have other thoughts.
Thank you very much for that. Also, just as an indication, the legal team, which has been noted, or the technical team for the AFN, which has been noted in the chat function, has prepared some background documents, and they've tried to address a number of these issues. And so I think there's about 5 documents, and really want to encourage everyone to take a look at those leading up to the meeting. Did any of the other legal members of the legal team wish to speak to that question before I turn to Councillor Gardner? If not, I've seen Councillor Gardner raise his hand literally. Let's go there. Edward.
Thank you very much. And I likewise thank for this session to be opened up in a good way, and my thoughts and prayers go to Grand Chief Philip Stewart. This is a very, very far-reaching piece of legislation that requires some in-depth analysis, as we all know, and there are many people, as has been expressed across the land, who have raised various concerns, from outright rejection to some other criticisms. But there is a document called Defenders of the Land Truth Campaign, and I don't know more. They issued a press release, and they had legal counsel that took a hard look at Bill C-15, and is of the opinion on one point, especially pressing home the importance that Canada needs to acknowledge and recognize that the Constitution of Canada, one in 1867, and equally the 1982 Constitution Act, are based on the doctrine of discovery and terra nullius. And there's an expression of intent that this be acknowledged by the actually inside the legislation, not in the preamble, but right inside the legislation document. I'm just wondering if the legal counsel and the leadership at the that the AFN and other organizations have taken into account or examined or is preparing any kind of response to the concerns that they raised.
Thank you, Councillor Gardner. So again, maybe on the legal side of things, we'll look briefly there, and then we'll look to the Leadership Council for a response as well.
Thank you, Harold. I didn't realize the seat was going to be so hot. It's, I think one of the, I think the easiest direction to redirect that concern is to take a look at C-15. And sorry, I'm not very astute at easily sharing my screen, as you've seen. But under C-15 section 2, sub 2, the statutes currently in its current draft states that the act is to be construed as upholding the rights of Indigenous peoples recognized and affirmed by section 35 of the Constitution. And then it has the normal non-derogation language and not abrogating or derogating from them. So, I mean, the statute does, in its current draft, make specific reference to the constitutional status. It's not just in preambular clauses. I mean, there's an excessive amount of references into in the preamble, but there is a substantial section in sub 2 of the current bill referring to the constitutional status or to the Constitution itself. And then there's multiple references even in other elements. So it's both a positive and a negative. It's non-derogation, and it's also saying that the declaration must uphold section 35. So, I mean, I think that would be probably like some of the initial sort of thinking on that particular concern.
And perhaps could I look to the Leadership Council for a response as well? Regional Chief TG.
Thank you, Harold. And I think that's really part of the discussion today, is to have those positions brought forward to the national discussion in regards to some of the concerns. In particular, I believe it was Article 45 and 46 that were concerning Ontario. I did a presentation to Ontario about the experiences that we had here in British Columbia about implementing the Declaration Act, Bill C-41, knowing full well that during this time, it's been over a year, and we were still developing an action plan and not even implementing the action plan. And that was the cautionary tale to Ontario, and perhaps to the rest of the nation, is that we need to implement this as soon as it is a bill, and not wait 3 years in terms of developing an action plan. I think these, what you're talking about with the issues of really, I think, getting rid of the notion of the doctrine of discovery, the doctrine of terra nullius is one of the positions we have here in BC. So I think, having that, having an action plan within a year, what was stated earlier by Chief Leah George Wilson, I think all these, these comments we need to put together and put that as a position to the national chief and to the federal government. Further to this, and we have to note too that the FNLC did have a meeting with Minister Lametti and Minister Bennett a year ago, January, to talk about their ideas of coming forward with Bill C-15. And we were pretty clear at that meeting and in terms of our position here in British Columbia and our experiences here. And then further to that what they were seeking from us was some direction. So I think here, once again, here's an opportunity to give them more direction to Minister Lametti and Minister Bennett and how best to do this, and our positions here in British Columbia. So thank you for that, Councillor.
Thank you. Thank you very much for that. I see Cookie Wilson raised her hand.
Yeah, good morning, everyone, and thank you for all the prayers for Grand Chief Stuart Phillip and his daughter, Lori, going through the surgery for the kidney transplant. And it's a lengthy surgery, so when we hear anything, Andrea said she'll let us know. So I just wanted to say, I'm not sure if it's answering the question directly, but I just wanted to let everyone know that the union did send a follow-up letter to Lameti. As you know, we're outside of the treaty processes and here in BC and outside of the 2019 treaty negotiation policy, even though the government and the federal government and provincial government signed that. So I just wanted to say, following up a bit up what Regional Chief was saying, that, we wanted the Bill C-15 to be consistent with all 46 articles of the UN Declaration and the 24 preambular paragraphs, that we wanted it fully implemented, not partially implemented. And our position cannot be watered down by entrenching colonial factors or Crown-imposed policies that limit or deny our inherent rights of Indigenous peoples. And I think that's what Councillor Eddie Gardner was speaking about, because that's what the concern is. And our Indigenous laws are still intact, our Indigenous legal orders, because what Regional Chief is saying is the UN Declaration is a human rights framework. So we still have our Indigenous laws and legal orders that are still intact over our land, and we hold the inherent town rights because we haven't signed those away in the processes. So I think it's really important how we evaluate, the potential alignment between C-15 and the Bill 41 here in BC, and we still have to push the government here for full implementation of, the UN Declaration here in BC as well. We do have something to work with, but it's still a lot of work in ensuring that legislation is included with us and part of the alignment of laws process. So I think that's going to be really important because the co-development of the legislation should have been more inclusive, but it was like a real tight time frame. And I think we had that town hall that spoke about those issues. And I think we had 4 issues with the Union BC and Chiefs that clause, at that time, clause 2.2 was not consistent with Bill 262. So we were wanting the word, wanting to return to another word on diminished, not that was used in Bill 262 at the time, but we wanted to be clear that Canada is repudiating colonialism and not in any form attempting to have the United Declarations, the UN Declaration on the Rights of Indigenous Peoples subordinate in any way. So we did make that clear in our letter. And we pointed out that Section 35 has 17 words and the Declaration has 46 articles and 24 preambular paragraphs. And it's the US Declaration we wish to have applied in law. And the old interpretation of our rights from the era based on colonial denial of our rights should not be entrenched. So we wanted to steer clear of that. And additionally, I think the other speakers spoke about racism. So we wanted to make sure that all forms of racism be eradicated in Canada, as well as the violence and discrimination. And the other part, the third one, was the removal of the words framework in Section 4B, which could very well, Merle might have pointed that out already, that our chiefs have expressed a concern about the various policies and frameworks imposed on our people in recent times by the federal government departments without our collaboration and then grounded in the denial of our rights. And the last one was, I think Cheryl spoke on, was the 3-year reference. It was the looking to a 1-year timeframe for the action plan rather than waiting 3 years. So those are, and some of I had some additional recommendations as a chief. One was the inclusion of the ALTA document that from the Global Indigenous Preparatory Conference be included. And I mentioned that at our conference or our Chiefs Assembly last year. And I wrote it in our Nisquana statements to the Medi when we had the town hall and submitted that. So, you know, the Alta document, our leadership from around the world already set out what an action plan should be. So that was just from our community at Nisquana. We had that from our Folsom. So sorry to take all the time, but I just wanted to explain that, you know, the Union BC and Chiefs did send a letter, and we did share our concerns with the First Nations Leadership Council and at our Chiefs Assembly as well. And we had those letters on file. Thank you.
Thank you, Kupi. As we look to see additional hands raised, maybe just double check a process question. I presume there'll be a BC caucus leading prior to the assembly meeting. And then I do see that Lydia Wisdom has raised her hand again. Over back to Lydia.
I'll try start my video again, but it's still not cooperating. Thank you again. Just really thinking about, oh, I see Judith has had her hand up, I think, for a while. Just wanted to comment around the process in terms of the Leadership Council's engagement with LeMedi and making the early submissions that DRIPA really, it can't, at the very least, it cannot compromise what we've been able to achieve as the standards in DRIPA here in British Columbia, and also pressed for ensuring that there is a BC specific process, that we get the real opportunity to have the sort of input, and this early discussion is really helpful in terms of trying to create that, as the points that Chief Judy raised around ensuring that we have, pardon me, ensuring that we address the whole range of issues, but also find a way that we can do the level of advocacy and support that is necessary from our group First Nations perspective here in BC. I just wanted to, part of the reason I was asking, I guess, about Article 46 and have been thinking about it is just this business of, as we go forward, whether it's treaty agreements or other constructive agreements or agreements made outside even of the BC treaty process, there's always that element or body of law around being, even though it's constitutionally protected, still subject to the infringement laws that the Crown had immediately created for themselves. So it was that sort of piece, and I know I don't mean to dive too deep on it, but I just wanted to make sure we had at least that sort of understanding around this table in terms of what is the pushback with respect to Article 46 and that territorial integrity piece, but also sort of setting it against the way the Crown works with us once we finally do get constitutionally protected rights, the body of law that around infringement. So I'm not sure where I'm going with this, but I just wanted to share that was some of the thinking I had around looking at as we go forward with this legislation. The potential is there, and I think we've all talked about that. It's just always trying to look for poking holes in it in terms of trying to find, are there any ways that this can be held against us as peoples? And one of the things I think that the Crown's been very good at is, once we do secure interests, they find ways in the context of their infringement strategy or laws to impact us. So I don't know if will this legislation strengthen us in terms of standing up to that infringement? I don't know, but that's some of the thinking. I don't want to put any legal on the spot because it is a complicated piece, but at the same time, I think it's some of the things we need to be thinking about. Thank you.
Thank you, Lydia. And I would note on that, so if you'll note in the chat, there are a number of issues around positions that could be taken and strategies that could be applied to continue to advocate for improvements in the bill. I do want to say to Judith, it looked like you had a virtual tie there when you and Lydia put your hands up. And so literally on my screen, Lydia's showed up, yours showed up, and then it changed the order. So I do apologize for that. I don't want it to seem like I was skipping over you. And so let's go to Judith, and then you will note that Ed John from Slesson has also raised his hand, and we'll go there next.
Thank you, Harold. I don't mind who gets to speak first. I think we have things that we need to say. And hello to everybody. It's great to see a few of your faces. I know a lot of people have internet connections, so you can't be being seen. I did have a call with Minister Lamedi last week and didn't really feel like he listened to me a lot, but I did raise the lack of consultation with First Nations across the country. And though he's trying to catch up and do that, that there have been many, many concerns regarding Bill C-15. And I apologize, I was on a press conference this morning and couldn't join you. So if I repeat anything, I apologize. But I think that, the Section 46 is a huge one. And I just think it's the same as Section 4, which is we're supposed to stay within Canada. But I always think that, if First Nations are going to leave Canada, that nothing's going to stop us. No law, no international law. We're just going to do it. And that this act is going to impair Section 35 rights. And we heard from Merle about, the non-derogation clauses. I'm also hearing a lot about UNDRIP affecting our Aboriginal rights. And I've seen a lot of letters from across the country expressing their concerns over Bill C-15 as well. Just watching that. So I guess when we go into the national meeting, I'm just wondering how BC can address these. I mean, if we're supporting Bill C-15, how do we talk to, or is there a way we can work with the other First Nations to address their concerns? Because, they've been quite vocal about it. And I've seen a lot of articles about how this just isn't what we need to do. So I just wanted to kind of go in with a strong position if this is we're going to do together. I talked a lot to the minister about the lack of teeth, as in DRIPA here in BC. Their UNDRIP Act is the same. There's nothing in there that makes the government do things. They have to table an action plan, and that's not much teeth. And so we need to be suggesting some kind of mechanisms to make the government implement the UNDRIP. And what is that going to be? And also to set up an independent body that has teeth to make the federal government and First Nations work on these things. One of my biggest concerns here in British Columbia and in Canada is how do we define some of these terms? I mean, self-determination has to come from the nation. Self-determination is our path forward. And that's a definition that has to be individual. But, terms like free, prior, and informed consent, restitution, compensation, those kinds of problematic words mean that if we can't come to an agreement with Canada, then they're going to sit there and we're just going to become frustrated. And I think this is the same frustration we suffered during the new relationship because we didn't know what joint decision making was and we couldn't come to an agreement. So how do we get those terms defined? And maybe an independent body could help us do that. I'm not sure. But I really think if we had an independent body that would make the federal government do their work under UNDRIPA, that it might help. So I talked to the minister about that last week, and he seemed to be more open to it than I've heard him before. So I also had a discussion with him about having a section in UNDRIPA regarding what happens if, we get a conservative government and they want to repeal the statute or amend it in a way we don't want. And that really should be a clause in there regarding if this act is to be amended or repealed, the free, prior, and informed consent of Indigenous people must be given. And he kind of poo-pooed that and said, well, Harper did finally agree to UNDRIP being implemented in Canada. And I just kind of rolled my eyes that he couldn't see me. But you know what I mean. It's possible. We've seen racism rise in this country. And so I just thought, as if we're going to keep something in place for a while, we should really have that sort of a clause in there. Really quickly, I agree with Judy. I think that, you know, it talks about systemic discrimination. I would prefer to see racism in there. Racism, and if we have to say racism and discrimination, all the discrimination should include it. But I think we have to name the problem, and the problem starts with racism. And I'd like to see us, you know, continue to push that. And just, you know, in the last, at the AFN AGA, we had very little time to talk about the proposed Bill C-15. And we had Willie Littlechild going exhaustively through the preambular paragraphs and how wonderful they were. You know, and I just think looking at the law, and Merle did touch on this a bit, you know, the preamble is just nice frilly words around something. The courts don't really rely on it. And so I don't care what's in the preamble. We could do without a preamble as far as I'm concerned, because what's important is the meat of the statute. And if it's not in the meat of the statute, it's not going to work. So anyway, I just really wanted to, you know, last time we didn't put the motion forward at the AGA because people were all over the map, and we still are. And so how are we going to be prepared to go into the meeting next week? Is it next week? Or 2 weeks from now, in the national level? And because it's going to be difficult to get on the speakers list, to be promoting anything. And so just trying to figure out a way whether or not we can unify across this country. What is Justice, Minister Lametti going to say? If half the First Nations in Canada don't want it, like what is our strategy? And just would love to hear some more discussion about how do we work together, and how do we make Bill C-15 something that is workable, and with the mechanisms and pushing the Canadian government to do something, because, you know, so many of the court cases we won at the Supreme Court of Canada have never been implemented, such as the Hausa case in fishing. And, you know, having a tool there that should work and not being able to use it, it just does nothing for reconciliation or unity, or even advancing our rights as Indigenous nations. So just wanted to say those few words, and thank you for the time.
Thank you very much, Judith. Let's go to Ed John, and then we'll go to Robert Phillips. Ed, I'll just ask you to unmute.
There we go.
There you go.
I think I'm muted here. Okay.
Yes, you are.
Thank you. I want to thank the Leadership Council for convening this session, also the preparation for the meeting next week. On behalf of Glasden, just wanted to send my prayers to Stuart and his daughter today as they undergo an important medical procedure to deal with Stuart's health concerns. Wanted to also send my prayers to members of all of the families across this province who have lost individuals and family members to COVID. One of my last two aunties, she lost a brother and two of her sons in the last few days, and has had a major impact on our family and our community as well. And I know the difficulty that many other communities are going through. In light of all of these initiatives, I really appreciate the comments that were made. The context of racism and systemic racism is true and real in this country, as we know. The TRC called it cultural genocide, or even further genocide. And, you know, this is the context we need to understand in the history of colonialism. And we, as Judy mentioned, we don't, Judith, we don't mention the issue of cultural genocide within the context of colonialism, and we're presupposing that. I'm mindful of the discussion around Section 35 and the 1735(1) and the 17 words that says that the Aboriginal people, so the Aboriginal treaty rights of Aboriginal peoples of Canada are hereby recognized and affirmed. And when this matter first went to court in the Sparrow case, and later in Delgamuukw, the first arguments the government's put forward, well, it doesn't really matter because the word exists in Section 35. Those rights don't exist anymore. They have been extinguished. So, you know, I think we're mindful of government conduct and government arguments. My view would be to be mindful of that. On the question of the doctrine of discovery, it's an important concept. It originated in the Marshall Trilogy of cases in the US, in the United States. 3 cases where Chief Justice Marshall invented the idea of the doctrine of discovery. And basically it said that, you know, what remains upon the colonization and the assertion of sovereignty of then the British Crown was what remains was internal sovereignty of the Indigenous peoples, and the concept of Indian title came up. Now, the doctrine of discovery was first applied in Canada in 1888 in the St. Catharines Million case, and then in Calder in 1973, and then in Delgamuukw, and then in Chilcotin in 2014. The Supreme Court of Canada continues to apply this provision, and it is a concern because it justifies in British Columbia the taking of Indigenous lands in the colonial era by the likes of Governor James Douglas, the first governor of the province, where he issued a proclamation on April 14th coming up, 1859, that said that all lands in British Columbia belong to the Crown in fee. No, nothing more, nothing less, just that it belongs to the Crown. And that's the nature of the doctrine of discovery in its application. The doctrine of discovery is one of these conceptual foundations for the federal government and its mandate under 1991-24 to begin the residential schools. And we know the horrid history of that. So in respect of that, I think questions need to be raised with Lamedi next week with regard to where the Crown will go. I should note that the doctrine of discovery, and it's the way it's being used in 1888, the Treaty 3 and First Nations were not involved in that court case, but the court in London, the Judicial Committee of the Privy Council, applied the doctrine of discovery without the benefit of any legal argument or any comments from the Indigenous peoples in Treaty 3 area. Similarly, in all the subsequent cases in Calder, Delgamuukw, and in Chilcotin, that argument was never made, yet the court continues to apply because of precedent that doctrine of discovery, and it has very serious implications. And so I think we need to make sure that we raise this with Lamedi. On the question of territorial integrity, I think, the 46, we need to read the whole declaration together and not in isolation. 46.1, of course, talks about ensuring the territorial integrity of a state. And then it goes on in 46.3, the provisions set forth in this declaration shall be interpreted in accordance with the principles of justice, democracy, respect for human rights, equality, non-discrimination, good governance, and good faith. So there's a tempering provision of the Article 46.1. Terry mentioned Article 45, and I think it's important that we take a look at that. It reads, Article 5 of the Declaration, nothing in this declaration may be construed as diminishing or extinguishing the rights of Indigenous peoples have now or may acquire in the future. So there's a protective provision in the declaration for this level of concern. But I think we need to make sure that the linkages are made with respect to that. The other provisions, Articles 1 to 45, the way I've looked at it, those would substantially be the territorial integrity of Indigenous nations in British Columbia. Particularly Articles 25 to 32 dealing with lands, territories, and resources, and Articles 3 and 4 of the declaration, which deal with the right to self-determination and the right to self-government. Let me read this. I've sent this to the Leadership Council members, and it's a report in December 2020 from the International Law Association from their Kyoto conference on the implementation of the rights of Indigenous peoples. And Professor Daley Sambodoro from University of Alaska, an Inuit expert in this area, is a co-chair of that particular committee. And what they conclude is that the ILA, the International Law Association, found that Indigenous peoples' collective rights to their traditional lands, territories, and resources, 1, 2, to their cultural heritage, 3, to their self-determination and autonomy, and 4, to the reparation and redress for the wrongs they have suffered, have reached the status of customary international law. Now, that's very significant in this. These provisions, many will recall, were taken, for example, the right to self-determination is in the UN Charter. It's also in the first 2 international conventions, the covenants, civil political rights, and covenant on cultural rights, recognize the right to self-determination, and it includes Indigenous peoples, but those provisions were taken out and put into the UN Declaration, so those provisions in and of themselves are part of what the ILA, the International Law Association, called the status of customary international law. And I think it's significant in this regard. I wanted to make those points with respect to some of the discussion. I appreciate the comments by legal counsel and as well as our leaders on this matter. I really think it's important, as was stated earlier, that BC continues to demonstrate leadership on this matter. It's, as I see, Bill C-15 is built on 262, which we supported. So we should make sure we continue to stand by these issues, but make sure that we raise these really important issues that have been brought up today as matters of concern, which whether they're dealt with in amending the bill that's before us or making sure that this is included in the action plan. You know, I heard about the action plan. It's going to be delayed. My view is get on with doing the work, what you want to see included in the action plan. Don't wait 3 years down the road. Begin that work. And I think what Judy Wilson mentioned, Cook B. Wilson, was the Alta document. Alta, Norway, is where the gathering of the Indigenous peoples took place prior to the World Conference on Indigenous Peoples at the UN in 2014. That outcome document from the World Conference on Indigenous Peoples in September 2014 is absolutely a required reading, and I would recommend it to a leadership council to bring that forward and to disseminate that, because in there it talks about what the commitments have been made by the UN as well as the member states as to now what do we do with the declaration that now that we have it. So Harold, I appreciate, I know I've gone on a bit longer than other colleagues, but I wanted to make those comments with respect to the discussion now, and really appreciate the Leadership Council convening this.
Thank you very much, Ed. I appreciate that. And over to you, Robert Phillips.
Yeah, I know we're running out of time, so I'll skip the usual introductions and everything else. I think when it comes to DRIPA and UNDRIPA, we need to make sure that the work, as Grand Chief Ed John already said, begins. And I think President Judith Sayers hit the nail right on the head as well, that we have to make sure it's implemented. And because we know that there's going to be delay. The opportunity is here right now with the Liberal minority government in place, and it looks like there's not going to be an election. And as well, it looks like with the government that we have here in British Columbia, that the opportunities will begin. Now, we know there's been a lot of frustration in the past year with DRIPA, and we know that we're going to be pushing the government as much as possible. We understand there's going to be capacity issues. There's going to be a lot of expertise and as well throughout Canada. And I know that we need to involve the leadership as much as possible. A lot of times the federal government does tend to go towards the AFN. No offense, Terry, because you're BC AFN and we do work a lot together. And I know that you're one of many regional chiefs across Canada. And so we need to make sure that as champions, like Cheryl had already mentioned, that we push this and we push it hard. And just looking at the involvement of the leadership is so important because we have that expertise right here in British Columbia. So I know that when it comes to a lot of the work that we have been doing, that our voice has to be heard. And we know that First Nations organizations, our own as well, have been working on some of this. So I don't want to see us getting caught up in too many silos, that we need to work together. And even the Leadership Council itself, 3 different organizations here in British Columbia, sometimes we have differences as well, especially when it comes to treaties, agreements, and other constructive arrangements, which are in the UN Declaration itself. And we know there's going to be a fear factor from those across Canada, whether it's First Nations, but as well as industry, as well as governments, and especially in your own backyards, local and regional governments, where there's going to be misinformation, where there's going to be fear of free, prior, and informed consent. We already seen it in standing committees, one after another, especially with the conservative and reformers and those kind of people. So I think when it gets right down to it, that not only do we need to be in co-development, not only do we need to be involved with the laws in British Columbia and as well as Canada, but we, as already said, we have to make sure we develop our own laws, our own inherent rights to self-government, our own, whether it again, the agreements that we have in place. So a lot of work, and it's going to take time, and time is of the essence. So thank you for your involvement and participation.
Thank you very much, Robert. I would know we have time for probably about 2 more interventions. And I did also want to draw the First Nations Legal Council's legal team, or First Nations Leadership Council's legal team, to Cookby Christian's comment in the chat regarding justifiable infringement, and ask that that be given some attention in the chat as well. And I'll look to the finals to see who wishes to raise their hand. That's the final 2 speakers. I do see Cheryl literally raising her hand. And then yeah, so over to Cheryl.
Thank you, Mr. Chair. I just want to build off of President Jude's comments, as well as my colleague, Robert Phillips. First, starting off with President Jude in terms of, what is our strategy moving forward? And we were hoping that this forum would allow for an opportunity to hear directly from leadership in terms of what it is that we were going to do, what kind of a position we were going to be going forward with, particularly for the meeting next week. And further to that, what could be incorporated in some of our submissions, because I know that many of us are going to be looking to making submissions to the standing committee. So, and then Robert spoke about the fact that this is a Leadership Council forum, but it's made up of 3 different organizations, and we have different mandates. And I know that I know that the organizations themselves have probably obtained legal opinion as well to keep in mind what your specific mandate is. And so the summit is no different. And I think that it might be important to share a few things from legal advice that we've received, so that those individuals who are summit reps on the table will all, will be aware of what we've been advised. And so keeping in mind, I haven't talked to my colleagues about this, but I'm not going to share the entire thing. I just wanted to point out some key things that was shared with us. So around Section 4 and the purpose of the Act, it was shared with us that the 4B talks about a framework, and it was brought to our attention that typically legislation doesn't make reference to a framework. If anything, the legislation just gives you the statutory power to go ahead and make the law, to implement the law. And in this instance, though, it was suggested that a framework might allow for Indigenous peoples to be more involved in the development and engagement of what that process is going to look like. Further to 4B, it talks about framework for the government of Canada. And it was again brought to our attention that that's a narrow scope. It talks about the federal executive branch of Canada, but it doesn't talk about all of the other executive branches, including branches of provincial power. So we may want to consider that, may want to make a little bit of a change to that. It certainly will be something the summit will be considering in its submission. Also, in relation to the action plan, we discussed about whether it should be an action plan or an implementation plan. I know here in British Columbia under DRIPA, we do talk about the action plan, and we have seen some challenges with the development of that, but you know, it's still part of the work that lies ahead of us, and we're starting to make some headway. Now that we have Minister Rankin on board and we have a majority NDP government in place, we think that we're going to be able to provide leadership a copy of a draft action plan before the end of the fiscal. So that's just a side note for chiefs to be aware of. But in this instance, is it really necessary to have an action plan as opposed to having an implementation plan? And we may want to talk about that. Under content 2A, it lists a number of measures. And what was brought to our attention is that those measures that are listed in A are all captured in the articles of the declaration itself. That's the basis of what the declaration is about. And so do we really need to try to have that in here when we should be talking about the implementation of the declaration and not really breaking it down to these subsections that are listed? However, we may need to be looking at taking all of the pieces of the statutes that currently exists, which is a part of number 5, and maybe looking at themes. But for this instance, what was being cautioned is that this may be used against us for needing to slow things down so that we have to address each of these specifically. So maybe we might want to look at maybe making some small changes to that. And in relation to other elements on 3, what was shared with us there is that it was undue emphasis on implementing action plan versus implementing the declaration itself. So again, just something to consider. And that's just a short snapshot of things that were shared with us during our review. But I thought it was important for us to share and highlight some of the significant points of that opinion as we start thinking about and working towards working on our strategy moving forward. So thank you for that time, Mr. Chair.
Thank you very much, Cheryl. I don't see any other hands up. We are at 11:46. Okay, Lydia's hand is back up. So I did want to maybe just, is there a last call for any additional speakers before I go to Lydia? All right, and I'll go to Lydia, then back to Regional Chief, and then we'll turn to Chief Tom to conclude the meeting. And I do want to acknowledge the presence of Mary Ellen Chappell. I know a number of us were having technical issues this morning with this forum, or not with this login. So I think it was more of the systems issues than any of our issue. Let's go to Lydia, then Regional Chief, and then Chief Tom to help us wrap up.
Okay, thank you, Mr. Chair, and thanks. Just acknowledging all the comments before me, in addition to Cheryl's comment, I'll add just one point with respect to the action plan. I think that was another piece when we, as C-15 kind of sets out, here's an enumerated list of things we will address under section 6.2. And so, the other aspect of that was, well, hold on a second, we already have, the purpose of this legislation is to implement the human rights standards that are enumerated in the declaration. So to sort of have the bill set out a number of things doesn't necessarily capture the fact that we're trying to implement the declaration. The second piece I'll just be quick about is thinking about how we move forward in BC and trying to find a way forward, because I think there's there's real value in us moving forward with this legislation, but we also understand that there's some ways it can be strengthened. And so just trying to find a, trying to find a balance in there in terms of respecting the fundamental principles of self-determination with respect to that the Declaration enunciates and has as a foundation for Indigenous people. So just wanting to add those couple of comments and thinking about how can we support it in BC, understanding that there are ways that it can be strengthened, and try to do that, capture it that way in terms of trying to ensure that Canada gets this tool. Canada's the one that needs this tool, right? And so I'll just stop there and just look around the table virtually and thank you all and acknowledge you all for this, for all of your good work, and wishing you well. I'll stop there. Thank you, Mr. Chair.
Thank you very much. Regional Chief?
Yeah, just working off of some of the comments made by President Jude Sayers in terms of strategy. I think what we need, and the reason for this forum was to get a perspective from all leadership and perhaps go forward with perhaps maybe a position paper or some recommendations that we can put forward to Minister Lametti and the federal government. I certainly agree that as here in Bill 41, to have a secretariat to make sure that laws are compliant with the declaration, and also including racism and the recommendations that you brought forward, President. And this is a comment to all leadership here, is perhaps send in positions, recommendations to us. That's really what the purpose of this forum is, and that's what we need to come forward with in terms of next week. And I certainly know that Mary Ellen has some recommendations as well, and perhaps we should go to her. And I know you have a forum tomorrow, or UBC, that there's another opportunity to have more discussion on this matter. So thank you all of you, to your communities, prayers to everybody, going through this very difficult time, as stated by many of you. Have lost loved ones to this terrible disease, COVID. So thank you, Chair Masicho.
Okay. Thank you. And so a number of members of the Leadership Council have asked that we give a few moments to Mary Ellen. And you'll note in the comments that some people have already commented about recommendations you've made as well. So if I could, a brief comment before we turn to Chief Tom to wrap up our session.
Yes, thank you very much, and apologies for the technical barrier, but I was keeping notes and getting informed of the comments that were being raised. I think I think my running tally right now is I've seen about 10 or 11 key issues that chiefs have been raising, and areas, not to say that Bill C-15 couldn't be helpful, but that things that are absolutely needed, basic issues like including reference to racism explicitly. I know Chief Judith Sayers has raised that from the beginning and put that forward. And I know through the UBCIC letter that Kupti Judy would have mentioned as well, a number of these issues have already been brought forward to Canada. But there were also issues raised about wanting perhaps to add reference to renouncing doctrine of discovery, doctrine of terra nullius, even though, legally it might be covered, just to be extra explicit because of how significant it is to title and rights in British Columbia. So I've been pulling together with the other members of the legal team the various points that have been raised. There have been some concerns also about whether or not some of the wording is strong enough, it's consistent with 262. There are some significant areas where I think it will be important to bring it to the parliamentary process. And none of us knows exactly what that's going to look like right now, but I do certainly encourage all of the chiefs to bring your information up and put it in directly to Attorney General Lametti, but also working through the organizations. As RCTG mentioned, I think we will be preparing some sort of common paper. I certainly do have a document that's listed all the interventions the chiefs have been making, including I've been receiving a lot of email traffic from legal counsel asking questions. And I did have a session this week with the Yukon First Nations as well, and they raised some similar concerns. And they were planning their process. So I think we have the national meeting next week. That's fine. That's a discussion forum. But I do think that specific proposals to strengthen Bill C-15, it is the time to bring it forward. And there have been issues. I also have heard issues about the consultation and the inadequate time frame. I think that's a hard one to fix at this level. But I think the issue about what is the action plan? If it's an implementation plan, can it be British Columbia specific, or does it have to wait for a national plan that could be years down the road? So some of these political comments are coming forward, and I think it will be important to technically collect them and bring them up. But there are specific proposals that I've heard repeatedly that we do need to prepare after this forum into some kind of a summary document and share back with everyone. And obviously within the 3 organizations, that work is progressing. I know within UBCIC, there's a lot of documenting the concerns of chiefs and advisors and others. We are having a bit of a public event tomorrow. It's not a First Nations specific event. It's really to involve community responses, because as you've heard, 6 provinces are vehemently opposed to this bill, and some sectors of industry and others are as well. So there is a lot of misinformation around that. But I would say legally, the biggest concerns that I'm seeing are to make, there's a debate nationally. There are some quarters that do not want to support Section 35 based decisions under the Constitution. And they feel that legislation, if it entrenches what's been decided under Section 35, is not progressive enough to implement the declaration. That's a debate that we're hearing, and we've heard some comment internally on that. So we're processing that and finding a way to, of course, uphold and recognize the hard work of BC First Nations who have won path-breaking Section 35 cases without having the declaration there to assist. But also to be able to build forward on that. So this is a point of contention and there is some misinformation. So we're going to process that. We're going to try and find some options to bring back for chiefs and others to look at. But I do think there's a window to make improvements. And I think a lot of them are very obvious and going to be achieved, like Chief Sayer's identification of the deficit around not naming racism. Other pieces are going to require presentation to a committee, consideration by a committee at second reading to amend the bill. Because once a bill is in process, it's in process. Government of Canada, though, from my impression so far, has said that they are very open and they want to know what the chiefs of BC view, how you view this, and to make sure this works. So I think there is lots of latitude to have more discussions, but the time is very compressed.
Thank you very much, Mary Ellen. I appreciate that. Just as a final contextual for the AFN meeting forum next week. So in the online environment, as you've seen, AFN does not arrange regional caucuses, so that is left to each region to arrange those as they desire as an external component. But with that, we'll turn to Chief Don Tom for the sort of concluding remarks from the Leadership Council perspective. And then as Councillor Paul Sam had been so good as to offer the opening, perhaps we'll look to him again for the closing. Chief Don Tom.
Thank you, Harold. And I just want to express my appreciation and gratitude for everyone's warm wishes and prayers for Grand Chief today. It is a difficult day for many of us who are keeping him in our hearts. And as Robert had mentioned too, we're keeping in mind all those in your communities, your respective communities who are going through the challenge of this global pandemic and difficult times. And we appreciate you taking the time to be here with us today and provide direction as we move forward. And thank you to our technical team who also helped us today. And thank you to Harold for the fine chairing today and bringing up Rustad. I also had a flashback. Thank you. Just some closing remarks. And as I think about this, when I look back at our history, we're generous people with rich culture and rich language, and that we have always been kind people. And we look at the doctrine of discovery and how we're barely even human, and these sort of colonial contexts of, I think, how the federal government looks and implements their laws and their engagement with us. And so we're embarking on a transition here, and I think it's one that's really exciting. And I think of, in my mind, I think that we must leverage the sacrifices our ancestors made for us to keep our languages alive and our rights here with us. And we know that the laws and policies and practices must be changed within Canada. And I think of some of the excitement that we had after the Chilcotin decision, that we came together. There was some enthusiasm there. We developed 6 principles. I think our enthusiasm is still there. And so this is real opportunity for us to work and collaborate together. And, moving away from things like consultation, where we're helping the government infringe upon our rights. And we're moving in a completely different direction, and which requires a lot of work. We will be instrumental. We'll have some work to do as this advances, whether it's in the Senate committee or the implementation piece. And if we look at some of the work that has been, or some of the racism that our members are facing here in BC, I think we need to add racism in there, and that racism be addressed in the preamble, because it needs to be explicit. I don't think it's explicit enough, and we would benefit from having racism be more explicitly added in there versus discrimination. I also just wanted to mention that Minister Lametti will be attending the UBCIC Chiefs Council February 25th to discuss C-15 with the Chiefs. The rights of our Kwalmuk people and of our Indian people. When I think about that, and I think about where we're going with C-15 and what's being proposed by the feds so far, and I agree that we need to be involved in the implementation. It's not enough to engage with the chiefs. We have to be involved in the implementation. How dare they create legislation for us and then decide what is best for us and how to implement that for us. So we have to have our say in there. And I think looking at the doctrine of discovery, and we must create the action plan. We must be at the forefront of implementing this and making sure that our rights, our title are included, and that our interests are represented. And it wasn't that long ago, many of us were in court fighting for these very things, and they were denied by the courts. And so there's been a long, hard fight for many of us to even prove our existence in the courts. So it's exciting to know where we're going, but it requires a lot of work. And I know that we can do this as BC to ensure that the work that we've done here with DRIPA in BC, that the hard work that we've done there, that our rights are maintained there. And in the action plan, I think some of the learnings that we've had from BC is that we must not wait, and we can't wait for a 1 year, 3 year period. It has to be a 1 year. It has to be, and must actively involve us as First Nations. But thank you to the chiefs today for your remarks, and as the good fight continues. And as I'm reflecting on Grand Chief Stuart Phillip today, for someone who grew up in the foster care system, someone who didn't have access to language and culture, and looking at the work that we're doing with C-15, the importance of maintaining that for those individuals who may not have access to our language and culture, that these opportunities are afforded to us. So just some reflections here today, and thank each and every one of you for partaking here today, and we will see you very shortly. Thank you, Mr. Chair.
Thank you very much, John. Let's turn to Paul Sam for the closing, and I want to thank everybody for their participation and for the opportunity to be your helper today. Over to you, Councillor Sam.
Thanks, Harold, for the chairing, doing an awesome job again today, keeping us organized and moving. And his clique when his cheese su makona cheese the chuck chay the nakwa don't eat quam to squirrel quinta su mako Haishka chaos su angstoch not the squetcho Haishka su angstoch with the quam squirrel quinta su angstoch the nakwa su mako etla cm chaos. I was thanking everyone in my language for bringing their hearts and minds to this session, thanking them for the great day, and thanking all of you for participating in this and again, leading all of our people in the work, the great work that you all do. So stay safe, everyone. Haishka chaos, haishka.
Thank you very much, everyone.
Thank you, Masik.
Thank you, everyone. Stay safe.
Have a good day.
Richie, thank you.
Bye, everybody.
Go.
On Winnipeg.
Feel like the Waltons at the end of a Zoom. Like, good night, Grandpa.
Good night, Dawn.
Take care.
Thank you.